jurisdiction level to $40,000. So we do a lot of work that falls within that area, and for that you go to district court because it's less expensive.
Look at me. This is ThinkTech Hawaii. Community matters here. Bingo. We're back. I'm Jay Fidell, 2 o'clock block. Scott Batterman is here. He's a principal of Clay Chapman down the block, and he and I practiced years ago together. Wow, exciting to have him here. Hi, Scott.
Hey, Jay.
This is Life in the Law. We're going to talk about Scott's career and what we can learn from it and glean from it, what we can teach young people about from it. So this is a big opportunity to sort of connect you and untold generations of possible lawyers. So if you had to define Scott, you'd probably say, okay, he's a construction litigator.
Yes.
This is not simple. We're going to get to that. We're going to define what a construction litigator is. But first, your background. Let me tell you what I remember, okay?
Mm-hmm.
Number one, got that? This is on the final exam. Number one in New York Law School, right?
Yes.
Law review.
Yes.
Whole thing. Tops, best. Okay, this is what, if you want to go to law school, this is what you got to ideate. Okay, also, you worked for a big Wall Street firm,
Actually, Midtown firm.
Midtown firm, sorry. What does that mean, the 40s, the 50s?
In this case, we were at 101 Park Avenue, this big, fancy new building that's 2 blocks south of Grand Central Station.
Okay, that'd be the
40s.
late 30s.
No, 40.
40s, okay. And that's a good location now. And you have the terminal nearby. And these days, the terminal is loaded with good stuff.
It was back then, too. They had the oyster bar there.
Right now, they got some fabulous restaurants in there. They got the clam bar.
Oyster bar.
Oyster bar down below, which is really, really good. And they got an Apple store as big as All Outdoors right there. It's huge. It's the biggest Apple store I can remember.
Of course, when I was in New York, they didn't have Apple, much less an Apple store. They had the big Apple, but not Apple.
So tell us, I mean, what did you tell us about the continuum that you had getting into litigation. Did you decide that in law school?
Oh, yeah. I mean, I did moot court when I was in law school, along with doing law review, and I always knew that I wanted to be an in-court lawyer, so that was everything I trained to do. And I got a job with Kelly Dry and Warren, which was a large New York law firm that had a very good litigation practice and still does. And with them, it was good because they had a wide range of things that a lawyer could do at my level. Because, for instance, we represented Chrysler Corporation. And so I would be a small part of these giant cases involving other major corporations. But at the same time, I'd handle their warranty claims in small claims court because for something like that, they're not going to send the big billing partner down there. They're going to send the smallest associate they can find who can string 2 words together to go down and do that. So that was good.
Yeah. So, but you learned about the big corporation in the process.
Yeah,
I mean, it doesn't come easy to understand how a big corporation works.
Each corporation is a little bit different. They have their own sort of characters and environment. I represented Union Carbide Corporation. I represented Chrysler. I represented smaller manufacturers. We also represented, some individuals with significant net worth for the estate area. For instance, we represented the estate of Annie Laurie Aiken, who was the mother-in-law of Klaus von Bülow, and there was a big estate fight there.
Oh, yeah.
We represented we were involved in something involving Rudolph Bing, who was the impresario of the New York Met. Those kind of things. We had a trust and estates department, so you'd get a piece of that kind of work also. If they had a litigation claim, the trust and estate lawyers aren't going to go to court. They bring it to the litigation department.
Sure.
We have other departments, and when they have issues, they bring it to the litigation department. So you get to see a little bit of everything when you're down there. Dealing with big corporations, depending on what level you're at. I mean, when I'm a young associate, I might occasionally meet with somebody important, but more often than not, I'm dealing with their in-house counsel, and everything's being filtered through in-house counsel. That's the thing about big corporations. They'll also have big in-house counsel firms, but they can't handle their own litigation because that calls for a specialty firm like Kelly Dry or other firms like that.
So what kind of big litigation matters did you get involved in while you were with Kelly Dry?
Well, we represented one of the defendants in the Agent Orange litigation. we were one of the last major antitrust lawsuits against the Bell system before the Bell system was broken up. And I think one of the biggest cases I was involved in, I think you know about, was the Bhopal industrial disaster litigation.
I remember that. We talked about that a long time ago.
Yeah, that was December 2nd or 3rd, the evening of December 2nd, 3rd, or 3rd, 4th, I forget. In 1984, there was a major release of methyl isocyanate gas from the Union Carbide India Limited plant in Bhopal.
This is going to be on the final exam. I hope you got the spelling on that.
And I don't want to laugh about it because over 2,000 people died.
I remember.
And many were injured.
It was first page headlines for months and years.
And we had represented Union Carbide for a very long time on a lot of other matters. I had represented them on a lot of other matters, both big and small. And again, small matters in state court involving, claims against, pool liners that they manufacture. And now we're in this big case. And eventually, what happened there was the Indian government took control of the case. They took control of the case and took over it. And then the federal court said, this doesn't belong to the United States. And they dismissed the case and went in front of an Indian court. So then we hooked up with a major Indian law firm in New Delhi. And I ended up spending 6 months in India on this case, in Bhopal part of the time, looking at documents, seeing how the story was being played in the newspapers, arranging for things when people would come over to handle the larger things. So I lived for 4 or 5 months at the Union Carbide compound in Bhopal.
Well, Bhopal's the northwest part of the country?
It's more like the middle. It's in a state called Madhya Pradesh. Bhopal, it's on the Deccan Plateau. It's right, it's in north central part of the country. Very hot in the summer, and it's funny. It's like 800,000 people, but it's still just a small town for all intents and purposes in terms of what we're used to.
Did you like living there?
I loved India. I found it fascinating. I made an arrangement with my firm that every other weekend they would fly me out of Bhopal to someplace where you could catch a flight to someplace else. Because from Bhopal, there's only you can only go a couple of different places. So I traveled around India a lot, partly on my nickel, partly on their nickel, and I liked it. It's a fascinating place to visit because it's so different from everything we know. It doesn't have the same, except for the British Empire coming in and taking over it. India itself doesn't have the same cultural references that we have of the Renaissance, Rome, and all the things that made up Western civilization. They've got an entirely different sort of a setting there, and I really enjoyed my time there. The architecture, the people, the food, everything. I got to travel fairly broadly all over northern and India, and I really enjoyed it.
I remember you took on an Indian accent there for a while. You were very good at it, Scott.
I'm not going to insult people by doing it on television, though.
I'm not asking you, no. Okay, so after that, you left Kelly Dry, and
well, not right away.
Okay.
Kelly Dry, again, one of the big corporations we also represented was Greyhound Leasing and Financial, which was a spin-off from the Greyhound Bus Company. And what they did was something like in the 80s, they had these tax deals whereby Greyhound would buy equipment, they would get the investment tax credits, and they would lease it to the end user. It was basically a financing. Instead of taking out a loan to buy the equipment, you would lease it from Greyhound. And there were tax benefits and things like that. And so this one man named Sheldon Player, and I can use his name because he was convicted, so there's no lying about it. This one man named Sheldon Player acted as a middleman, buying all this equipment. Greyhound paid for it, and then the equipment was then leased to these end users, and all the money flowed. The problem was there was no equipment, there was no end user, and
just the money.
Just the money. And he would then take some of the money used to keep the lease payments going, and he invested a bunch of it in Arizona real estate just in time for Arizona real estate to go completely into the tank. And eventually, Greyhound Leasing and Financial decided, let's take a look at the equipment. And that's when things fell apart. And the next thing you know, there's a major lawsuit, not just against him, but then he would use some of Greyhound's money to pay off people he had scammed before. And so,
what a guy.
So Greyhound sued the people that he was paying back with our money. And so what they did was they sent me from India to Phoenix. That's where the lawsuit started, because that's where Greyhound Leasing Financial was. So I spent 5 months, the summer in Phoenix, and I always thought it was amazing that, considering where I was, they found a place even hotter to send me than I had been.
They like to send you to hot places.
And believe me, Phoenix was over 100 degrees most of the time.
Oh,
and then after I'd been there for 5 months, they sent me to Salt Lake City, because what happened was the people that we were suing on behalf of Greyhound in this big RICO action were all in Salt Lake City. And the court said, I'm not sure if you can sue these people in Phoenix. Well, it's a federal lawsuit, so what we'll do is we'll just move the whole lawsuit up to Salt Lake City. And the judge moved up with it, because there were no judges in Utah who could hear it, because they were all conflicted out.
Wonderful.
So he would fly up to hear the case, and so I then spent the next 19 months in Salt Lake City, at which point, having been on the road...
Was it hot?
No, it was cold. And I'm from the Northeast originally. I'm from New York, obviously, and I don't care for the cold anymore. And it's one of the reasons I'm out here. So after 19 months in Salt Lake City, I'd been on the road like 2.5 years at this point. I said to myself, well, gee, I had nothing left for me in New York. This point, New York, this was pre-Giuliani New York, when it was like, it was nosediving, and nobody could see an end to it. Nobody said, oh, they're going to let Rudy Giuliani, who nobody really likes, and they're going to make him the mayor, and then he's actually going to make things better. And any part of that you told me, I wouldn't have believed a single part of it, but it all came to pass. Who knew?
We know now.
We know now.
We know exactly what's going on with him now.
Yeah, that's a separate issue. In any event, so I just said, okay, I'm going to go someplace else. One thing I learned when I was in Phoenix, and particularly in Salt Lake City, was that lawyers don't all have to be jerks to each other. Practicing in New York, you see somebody on a case, and there's huge stakes involved, and everybody's ego is showing, and you may not see this person again for the next 15, 20 years, so he doesn't have to be nice to you. And it can be really toxic dealing with New York lawyers.
Yeah.
And I'm not from the city itself. I'm from slightly north of the city, and this wasn't really, I could play the role, but it wasn't my favorite thing.
I'm sure.
In Salt Lake City, you saw, Salt Lake City is a small town. It's smaller than Honolulu, actually, I think. And the lawyers there, first of all, they looked at some of the way some of the New York lawyers acted, and they were absolutely aghast at their behavior and the way they treated them. And I could see it in their eyes. And when I dealt with them, they were just a lot nicer. And I just said to myself, okay, I don't mind going to someplace that's warm, a small town, as long as the economy is okay. And I'd been to Hawaii a couple of times, and I said, Hawaii would make a good sense. It would also move me several thousand miles away from my family, which was a feature, not a bug. And so I just decided I'm going to move to Hawaii. I interviewed with a few firms. I interviewed with your firm. I flew out on my own nickel to interview with your firm, and this convinced you that, okay, if he's willing to spend that kind of money, he's serious, and I got a job.
That was the message, yeah.
And and it was what I thought it would be. The difference between New York and Honolulu in terms of practice, it really is night and day. The stakes are not as high on a strict level, but if it's somebody's company, it's still really important to them. It's still important to the people involved. But you don't have these cases where you've got 20 lawyers on each side litigating.
Right.
And you don't have people treating each other nasty, because I'm a construction lawyer. That's what I do now. The construction bar is not that large. And you're going to see, I see the same lawyers over and over again. Sometimes...
You know what? I think if we take a break now, okay, and we come back in 1 minute, I'm going to see the same lawyers I saw before the break. What do you say?
All right.
That's Scott Batterman, construction lawyer, and more. We'll be right back after this break. This is ThinkTech Hawaii,
Getting what you need?
raising
Oh, yeah.
public
That's good
awareness.
stuff.
Let it flow, man.
Oh,
We're here for you.
Thank you.
Kindness. Pass it on. A message from the Foundation for a Better Life.
Aloha. I'm Marcia Joyner, inviting you come visit with us on Cannabis Chronicles, a 10,000-year odyssey, where we explore and examine the plant that the Muse has given us. And stay with us as we explore all of the facets of this planet on Wednesdays at noon. Please join us. Aloha.
We're back. I told you we'd come back, and I told you we'd see the same lawyers that we looked at before, and lo and behold, there's Scott Batterman, construction lawyer with Clay Chapman right now. Okay, and we're going to talk about the life of a litigation lawyer, construction lawyer, here in Honolulu after he had his experience in New York, in Bhopal, in Phoenix, in Salt Lake. Now we're in Hawaii. So, what did I miss?
The thing about, first of all, in addition to litigation, I also do construction consulting because, just as an example, Hawaii law is very consumer oriented and it's very complex, and construction companies, they do a lot of work for residential, and I would say that at least once a month, somebody who does residential construction comes into my office and they want me to do something for them. I take a look at your contract and I said, it's a nice contract, it's void, you can't use it, you cannot enforce it. In Hawaii, there are certain provisions that need to be in residential construction contracts, and this message hasn't gotten out to, I've given seminars about it, I've written articles about it, but it still doesn't seem to get out. Now, if you don't have these clauses in your contract, the court's going to look at it and say, this contract's void. It's an unfair and deceptive trade practice. You cannot enforce it. You can get paid if you prove how much your work is worth. But all these other clauses that you had in there to protect you, forget it. They're not good. And
that includes the license provision, right?
Well,
you have to be licensed.
You have to be licensed.
But that's not necessarily in the contract. That's just a fact.
Well, your contract also has to list your license number. But for instance, it has, just as an example, there are certain specific clauses that need to be in the contract. And there's a statute that says you have to have this, and also anything that's in the regulations. Now, even if you read the statute, if you don't then go to the regulations and include what's in the regulations, the court will not enforce the contract as written. And you're in trouble for that. Now, so I do a lot of drafting of contracts, also negotiating of contracts. And here's the thing. The construction bar, the good construction bar in Hawaii, the ones who know what they're doing, they are the same lawyers I see over and over again. Sometimes we're on the same side of a case. We're representing co-defendants. Sometimes they're on the other side. Sometimes they're acting as an arbitrator or they're acting as a mediator. Sometimes they're conflicted out and they refer cases to me. I refer cases to them. And
it's a small town.
It's a small town, and the construction bar, there are only so many attorneys there who are good at what they do and know what they're doing. And Hawaii construction law is itself unique. There are only so many experts in town to opine for a construction case, and you need to know who those experts are and who you can go to. So there might be areas in law, for instance, where you might want to go to a mainland lawyer. If you've got a construction dispute in Hawaii, you need a local construction lawyer who knows these things. And another example is, my firm, we help people get their license. Getting a license can be complicated. There are forms you have to fill out.
Contractor's license.
Contractor's license. It can be complicated. You need to know what form the Contractor's License Board wants to see things in. You need to know what information they're looking for, and we help people do that. A mainland lawyer is not going to know that. Now, there may be other areas where they might want to say, I want the big law firm from the outside, but when we deal with those cases, I sometimes act as local counsel for these guys, particularly in cases that don't involve construction. But if it's construction, I have to be the guy up front because they don't know the judges. They don't know the players. They don't know the law.
Did you ever associate with mainland firms, that mainland law firms that are involved in the case and maybe they're calling the shots and you're making the appearance?
Yes, to an extent. I'm not going to say anything I don't believe in. I'm not going to make an argument that my client, that's going to hurt my client. And frankly, when it's a construction case, they look to me and to other local attorneys to provide them with what they need to know. Again, they don't know the judges. They don't know they don't know the local rules of procedure. I mean, Hawaii has the Hawaii Rules of Civil Procedure, which looks like 48 other states. Then you have the separate local court rules, and they don't know about those unless they've
huge disadvantage.
So they need the local guy. Now, there are other kinds of cases, not construction, where, an example, patent-related cases, they need somebody to go there to represent them and to act, But I'm not a patent attorney, and I'm going to let the patent expert take the lead for that. And there are other cases like that that involve areas that are not in my specialty. The most important thing a lawyer needs to know, I think, is his or her own limitations. And I've seen this in the construction area. I've dealt with attorneys who didn't know construction law, and they got themselves and their clients into trouble because they didn't know what they were doing.
So you should specialize in the area because the stakes are often very high in construction cases.
Yeah.
And you're going to know more than somebody from the mainland. That's true. But what about all of litigation these days goes to mediation, goes to arbitration, and it gets settled. I shouldn't say all, but most of it. I wonder about
more than most. Over 90%. Very, very, very few cases go to trial. Some get settled early on. Some get dismissed by motion. Some get settled in mediation. Some go to arbitration. Some go to settlement conferences. But they almost all get resolved out. And that's an entirely separate skill, frankly, from the litigation skill. And for that, I sometimes lean on my partners to help in that area, because one of my partners is Jerry Clay, and he's like one of the leading guys doing mediation and that kind of stuff. So when I have a case that involves mediation, I bring him in to help me because he is himself one of the leading mediators, and he's good at mediation.
and if he's involved in a mediation, it doesn't work, he brings you in.
Yeah, or if he's involved in something, but the fight gets nasty. I've been involved in, bringing the guy from New York.
If we bring a New York lawyer in.
Yeah, exactly.
Yeah, but we know that you're a decent guy. We know you're nice anyway.
I try to begin. The thing about dealing with other lawyers in a small bar is, again, in a small town, you're not just going to see them, by the way, in court. You'll see them in line at the movie. You'll see them in the grocery. That doesn't happen very much in New York. I mean, 8 million people, you're not going to run into this guy. He's in completely different circles from you. But out here, you see each other. And if you're a jerk, pretty soon everybody knows you're a jerk. And people know who the jerks are.
What goes around comes around.
Exactly. Yeah. And the judges know too. Again, in New York, the federal court just in Manhattan had more judges than I think the entire state of Hawaii has state judges. That's just the federal court in one borough. So you might not see the same judge again. The judges might not like each other. They might not even know each other. But in Hawaii, it's a small group.
Yeah.
And if you get in trouble with one, they're going to know.
And it sticks. It's your reputation outlasts any particular case. It goes on for life here, which is a good reason not to tarnish it.
Well, when you think about it, okay, some judges are handling criminal matters, some judges are handling family matters. There are at any given moment, in terms of the circuit court, the main court for main trials, there are 12 maybe judges handling cases at any one time. You're going to get one of those 12, and if you've got an active litigation practice, you're going to get to know all of them. And there are only like 4 or 5, 6 federal judges, so
they're all going to know you.
They're all going to know
your reputation, whether they know you personally or through reputation. They know who you are. So, how has it changed? You've been doing this here in Honolulu for 30 years.
Yeah,
30 years. Whoa! You don't look that old. How has it changed? I mean, there are sea changes in everything in our lives, in our society, in every which way. How has it changed in the course of construction litigation practice?
Well, I think mediation is being pushed a lot harder. But interestingly enough, arbitration less so, I think, to some degree. What happened, arbitration originally was fast, dirty, simple. Now, then the lawyers got a hold of it. And now they've added all the things that you see in civil litigation. So now arbitration is almost as expensive. It's faster, but it's more expensive than it should be. If you instead take your case to a judge only without a jury, one of the big differences is you don't have to pay the judge except for your taxes. You have to pay the arbitrator by the hour.
Right, could be very expensive if it's a long arbitration. Yeah.
And I'm seeing more going to court, I think. I see a lot more.
The pendulum swinging back to court.
I think it is for that, but except for the mediation, everything goes to mediation.
What about juries? I don't have a good recollection about whether juries are the preferred method of determination of fact in a construction case or not. Is there a dynamic there? Is there an evolution in your experience?
I think in the entire time I've been in here, there might have been one jury trial that I'm aware of that involved construction. And it doesn't happen. In your construction contracts, you normally write so that it doesn't happen. That's number one. Number two is, one of the good things about mediation and arbitration also is that you can be somewhat more creative. There's something that you can use called an experts roundtable. Let me tell you about that, okay? The old style, you each hire an expert, they prepare a report, you take the deposition of one expert, they take the deposition of the other expert, you put one on the stand, he testifies, you cross-examine him, he goes home, next guy comes in, you examine him, he goes home. Very expensive, and all you're left with are two guys talking past each other, possibly. In mediation and in arbitration, what you can do is you can bring the experts into the room at the same time.
All together.
Yes.
And it tests them. It tests the credibility of what they have to say.
Yeah. To begin with, what you can also do is you have them meet first with each other so they can talk privately as to where they agree and where they disagree. And again, one of the benefits of being in a small town is these guys probably know each other and they know where they stand on things, so they can say, okay, this is this is that, this is where we disagree, and then you come in just for the disagreement and they can question each other instead of having the lawyers do it, and they know better what they're doing. And the arbitrator or the mediator gets to sit there and listen, the parties get to listen, then the lawyers can come in and ask some follow-up, or the mediator, the arbitrator can ask follow-up. It's faster, it's more efficient. I highly recommend it.
It leads to the truth. Yeah.
It leads to the truth, or it narrows the dispute a great deal, or it can. When it works right, it narrows the dispute, it sharpens the dispute. You get to see why he's saying this,
very good
why he's saying that.
Yeah.
And you can do that. And again,
You like to do that. You're doing that in your cases.
I do that whenever I can, when I can get the other side to agree to it, and I can get the parties to agree to it.
What about the dynamic, the evolution of technology in the past 30 years? We know it has evolved in so many ways, I mean, dramatically over that period. How has it evolved in construction litigation?
Well, the biggest thing in construction litigation is not spending 3 days in a dusty warehouse with 500 boxes. Okay, that used to be.
You mean you don't do that anymore?
The way construction litigation would be is you'd go to where the boxes were kept, and there would be a giant room, and you'd be going through them one at. No, everything's electronic now. That's number one. Is that everything's on an Adobe PDF, and you're going through it that way. And the other thing is that you can take these documents and make them word searchable, and you can put them in databases, and it's so much easier than having to go one at a time and get paper cuts and get all that.
Are the search programs going more to artificial intelligence? In other words, I don't want to only search for words. I want to search for a pattern. I want to search for an argument. And I need to have a wrap around the language in general.
I haven't seen that as much in construction, but the two other things about construction, okay? With digital cameras, and basically now, it used to be, okay, you take some pictures, but if you had a camera, you take the picture, develop the picture, maybe it came out, maybe it did, how much are you going to take, how much film are you going to spend on it? Now it's basically, take 1,000 pictures a day, what does it matter? So you have a much better record of the progress, movies, pictures, they're all available now in large numbers. You can see what happened. That's a big thing. And of course, the biggest thing of all is email, because now you've got email going back and forth, and now it used to be, again, there'd often be no written record because everything is done orally. But now I tell my clients, look, if nothing else, shoot off an email. And so the other thing is that as part of the work, now you have to look through 10,000 emails, which didn't exist at all before. And so that goes the other way and adding to the expenses, having to find all the emails. The other thing is, guy's got 4 construction projects going at once. He doesn't have a separate email account for each project. So you got to pull out the ones that relate to this project, or try to.
Oh, gosh.
And there are so many of them.
What about video? You can have certainly you can have a videotape deposition. That's been going on a long time. But can you have a video witness in a courtroom? Are they permitting that?
Yeah, I've done it in federal court.
Yeah.
You can do video depositions long distance also. I mean, I had a case where I did several depositions from my office to people that were on the mainland, and you have the record of that, and then you can play that for the judge. There's never a jury, really, but in federal court, the federal court is really very slick. The state court is further behind, but the federal court, they redid the federal courts so that now all the documents, all your exhibits are, by the way, used to be you have these giant binders of exhibits. You may still have them, but you don't look at them very much because you're also throwing everything up on a big screen. And that makes it easier to find things, and then you can highlight stuff on them. But again, the federal court, I had a witness who testified from Canada. Not a problem.
Yeah, incredible.
And the other thing is, the federal courts in Hawaii are very, very good on allowing attorneys to appear by telephone. So if you've got when you have these mainland counsel, if you have a hearing or you have a conference or whatever, they're all set up, just boom.
From other islands, from the mainland, anywhere.
From the mainland, mostly, but yeah.
Ah.
But
Well,
and I think this also, it used to be that on the neighbor islands, the judges were somewhat resistant to having you do things by telephone. It was like no, you show up in my courtroom. The current generation of judges is much more open and willing to the idea that I think they understand it's not the lawyer who's paying. The client has to pay to have the lawyer fly back and forth. That means the time on the plane, the ticket, whatever. You may cut them a break, you may cut it down, but still you're out of the office.
Glad they're getting that. Yeah.
You did. So now I'm seeing more and more the judges are willing to do it, but the problem is they don't have the equipment. So what they do is the lawyer has to get everybody together on his phone and then call the court in with everybody. So the lawyer takes care of the
second
conferencing,
best, yeah.
but it's still good. It's better than having to have everybody fly out over there for a 20-minute conference. Between the airport and everything else, you're 4 hours travel time for a 20-minute conference.
Last question, Scott. I've heard only a few days ago that the Chief Justice has indicated there's going to be electronic filing in the state courts and the circuit and district courts coming soon. Do you know about this? And how would it change things?
Oh, I do it all the time in federal court. The federal court has that, and I do all my own filing. I don't need. I can file from my computer, and service is made electronically. Also, everything's just done like that. You don't have to worry about running down to court or whatever. I haven't heard about that yet. I don't know that they have the computers for that. If they're getting it, that's wonderful. What they have now is just like a docket system, and it gives you some information, but not a lot. Other states have it at the state court level. Just about every federal court has it. Our appellate courts have it. Even some of our administrative agencies have it. I do cases. For some of my construction clients, I do OSHA type cases. And you can file electronically in an OSHA hearing. And you can file electronically in the appeals court. So they have the
technology is available. It's just
they
the
just
money.
need to bring it down to the circuit and the district court, because there's a lot more paper gets filed in a circuit and a district court than gets filed in an appellate court.
So last thing.
I hope they do it. It would be wonderful.
Yeah, I hope so. Maybe this coming year. There's camera one over there right in the middle. And out there are an innumerable number of people who might go to law school, who might want to be litigation attorneys, who might want to be construction litigation attorneys. What is your advice, Scott Batterman?
If I can't talk you out of being a lawyer in the first place, my advice is when you're in law school itself, try to get internships, try to get into law firms, find out what it's really like. Law school was an interesting experience for me, but the best things I got out of law school was the time I spent working either for a judge or with a law firm during the summer or during the year. Find out what it's actually like to be there, so you find out if it's good for you. And if it's not good for you, then figure out what else you want to do. But find out before you embark on it. Internships, things like that.
Don't you think that going to law school helps a person in general? And even if you have no intention of actually practicing, it's still worthwhile? This is a mixed question, I know.
Well, when I went to law school, it was $2,500 a year. And I was able to do it all on reasonable sized loans, and I was in and out quickly. I got a very good job when I left with a big firm. I was able to pay it off. When I went to college, it was cheap too. Nowadays, I don't know how much they're charging for law school, but if you're just doing it as a self-improvement method and you're paying $30,000 a year for that, I'm not so sure that that's the best use of your money, just because of how expensive higher education. That's something we have to do in this country. We have to bring down the cost of education. I went to MIT, and it was one of the most expensive schools in the country at the time, and it was still only $2,000 a year, and they covered a big part of it with financial aid. I can't imagine what it's like kids getting out of school today with $50,000, $100,000 worth of debt. That's no way to start a life. It prevents you from doing what you want to do. So there's one area that I'm really very strong on. It's bringing down the cost of education. We have to find a way to do that.
Thank you, Scott Batterman. Great to talk with you. Thanks for
Good to see
coming
you.
down. Aloha.
Aloha.
You know what?